My name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. When we have divorces and sometimes custody cases or property settlements without the benefit of marriage or whatever, but let's talk about divorce. When we have divorces, a lot of times the court, in an effort to not have to decide your case, will punt and tell the parties, you must go to a court-ordered mediation. What's a mediation? I'm very familiar with this process. I've done it many times. I've served as a mediator. I've had my cases mediated. This is basically a process where the court appoints someone, typically an attorney, who's not a part of the case, but who will try to use mediation skills and negotiation skills to find a middle ground so the case can be settled. And why? Because the court doesn't want to try that case. The court's not interested in making decisions and telling you about how to parent your child or how you might split your home or these valuable heirlooms. The court, to some degree, feels it will make that decision if it has to, but it is probably better if the people, albeit reluctantly, agree to something on their own, rather than have the court say, you shall do this, you shall do that. Court would rather not do that. So the court has this whole mediation plan set up. Now, when you mediate, there is often the exercising of what I call shuttle diplomacy. You have perhaps an attorney and the other party in one room. You are with your attorney in another room, and the mediator is in the middle. The mediator goes back and forth, and it's interesting. If you've ever come to our main office in Troy, you will see how we are set up like that, which is not uncommon in firms that specialize or have a focus in family law. Such firms might have multiple conference rooms with space in between so that they don't share a common wall, so nobody can hear what's going on in there. You have to walk across the hallway. You have one conference room here and one conference room there. That's how our office is set up too. So what happens is shuttle diplomacy is exercised, and the mediator will basically not be an advocate, but he will go to one party and find out what their wish list is on a particular issue. He will go to the other party, and he will make an effort to say, okay, you want this. I understand you want that. Well, what about if instead of giving you this, we give you that, but we make a concession on another thing? What about if you don't have, for example, Christmas Day, but instead we give you more of the Thanksgiving break? Or what if we alternate it and you take Christmas Day and Christmas Eve, but next year he gets Christmas Day and Christmas Eve? In other words, they try to figure out, are there common grounds? Now, there are certain things that you can say to the mediator to screw up that process, to make it not work for you. Number one, if the mediator gets the sense that you're really not making an effort to mediate, he's going to report that to the judge that the mediation's been unsuccessful. The court, not wanting to try your case and hoping that the mediation will work, is going to want to know why. If the mediator says that there is a lack of effort on the part of so-and-so to, in good faith, participate in the mediation process, that it will not bode well, okay? So you don't want to say anything which will show that you have no interest in this process. You don't want to badmouth the judge. You don't want to badmouth your kids or the other party. You want to stick with the facts. Let your attorney color those facts in the way that he or she deems appropriate based on your position. But you, as a litigant, don't ever want to appear as if you're acting in bad faith, as if you're not really trying to make this work. If you're able to do that, the likelihood of having a successful mediation, A, is greater, and B, if it doesn't work, at least the court won't think it didn't work because you didn't make the effort. When the court orders you to do it, it well expects a good faith effort. If you have any questions about that, reach out, and we'll be glad to help you out.